handling that.
Okay.
Heriberto Chavez. All right, and this is 25 DCCR 0559. Mr. Rojas is going to translate for us. And are you Heriberto Chavez?
Yes.
And Mr. Chavez, this is your initial appearance. And you're charged with deadly conduct. Hold on. You're charged with deadly conduct, discharging a firearm from May 8th of 2025. And since you've made bond, have you had an opportunity to hire a lawyer?
I don't make a lot of money. For a court-appointed lawyer.
So you tested positive in court for methamphetamine, and I raised your bond to $150,000 with a drug patch. How'd you make that bond?
I have a lot of family here and they all loan me money. I have a lot of family, parents and uncles and aunts.
If you can make a $150,000 bond, then you need to try to hire your own lawyer. So I'm going to reset your case for 30 days. So I'm going to reset your case to give you some time to hire a lawyer. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you cannot hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts and have different payment plans. You need to bring me back the names of the lawyers that you talk to so I know you're trying. And then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond again, and you would go back to jail. Do you understand?
So before I come back next time, I have to have a lawyer?
You're ordered to at least try to hire someone. And
So if they're charging me a whole lot, at least I'll bring you the page showing you the charges.
yes, at least for 3 different lawyers. Do you understand?
Continue?
Okay. Step in front of the clerk and sign your reset notice.
Sign right here.
Do you know why the one would have
It was
Joel
a
Vasquez?
rejection, and then they bonded out.
Gotcha. Veronica Randall.
Thank you. Thank you.
Thank you, ma'am. Christopher Morale. Good morning, sir. Are you Christopher Morale?
Yes, ma'am.
And Mr. Morale, this is your initial appearance in cause number 25 DCCR 0466. You're charged with the 3rd-degree felony offense of continuous violence against a family member from February 8th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yeah, I understood that I already had
Right. So when you're in custody, we automatically give you an attorney, but once you make bond, I expect you to at least try to hire your own. So I'm going to reset your case about 30 days to give you some time to do that.
Yes, ma'am.
If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Absolutely.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying,
Yes.
and then we'll discuss your options.
Very good.
If you don't do that, then when you come back, if you don't do that, when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
Understood.
Also, as a condition of your bond, when you made that bond, was it that you had no contact with Alonda Kelly?
Right.
Okay, make sure you follow that condition. No contact means obviously in person, but it also means communication in any way.
Absolutely.
No sending messages or anything, okay? If you do that and I find out, your bond could be raised and you'd be back in jail.
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you your reset notice.
It looks like the next one needs an interpreter and a positive holiday.
Okay,
I think he was in custody and needed an interpreter and then bonded out. That's how it
do you want to see if Jennifer can come down? Oh, it's Charlie's anyway. Hold on. You heard your name? I've got one that you were appointed to in custody that I think needs an interpreter on the initial. Would you mind handling that?
Okay.
And it was the brightest, prettiest, yeah. Good morning, you're Sydney Boudouin?
Yes, ma'am.
And Ms. Boudouin's charged with aggravated assault with a deadly weapon and cause number 24 DCCR 1944. And what is the announcement?
Judge, I believe Mr. Nichols and Mr. Roebuck have reached an agreement for a refile, and as soon as we get a date certain for that, we'll take care of it and dispose of this case.
Okay, okay, so I'll just do a normal reset. If something doesn't happen between now and then, obviously we'll need something to happen here on that next court date. Stay in touch with Mr. Roebuck so that you know when to go to the other court with him, the next couple of weeks or so. Okay, thank you. Veronica Randall.
Present, Your Honor.
Good morning, ma'am. You're Veronica Randall. And Miss Randall, you've been here before, I think, with Mr. Vasquez, and he filed a motion to withdraw, and I don't remember if I told you already to go try to hire a lawyer. So have you had an opportunity to hire someone or try to hire someone since you were here before? Is that correct? I think that memo on hers might be for somebody else.
Yes, ma'am.
Okay, sorry, that confused me. All right, so.
Trying-
All right, so Ms. Randall, what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of who you've talked to at that next court date, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail for not following that court order. Do you understand? All right, if you step in front of the clerk, she'll give you that reset notice. Mr. Roebuck, you have Sydney Boudouin. Sydney Boudouin, go get her.
She was at the office 10 minutes ago, so hope she didn't get lost.
It was. There were 2 amazing rainbows. There was one that was, a full one, and then another one on top, and it was the brightest, prettiest, yeah. Good morning, you're Sydney Boudouin?
Yes, ma'am.
Amenable to making certain stipulations
it will cut down the time.
Sure.
And witnesses in this case.
Sir, are you Larry Fletcher?
Yes, ma'am.
And so, let me, Mr. Fletcher is on probation and cause number 21-37809 for the offense of possession of a controlled substance, a second-degree felony. That probation is from October of 2021. It was a 5-year deferred probation. And then it looks like we have two new offenses that have been indicted in cause number 25, DCCR 0838, an aggravated assault with a deadly weapon, and 25 DCCR 0839, a manslaughter charge. Mr. Wilkerson has filed a motion asking that I set a bond in the motion to revoke case.
Yes,
Is there,
Mr. Fletcher.
hold on, is there any motions in the other two, or we're just talking about the,
I believe the state filed a motion seeking to actually increase the defendant's bond.
in which
Your Honor.
case?
Your Honor, I filed in both cases. In the NQRP, we filed a reply to the defense counsel's motion to set a bond. And then in the other two cases, the state, the aggravated assault and the manslaughter case, the state has filed motions to increase those.
Let me get that all pulled up real quick and then we'll get started. Hold on. I'm printing. I need to see all that. I just printed the response and
Okay, I'm sorry, I thought I printed it all for you.
it's okay. We'll get it.
Trim, waste them trees, man.
It's all your fault.
That's all my fault. It always is. In my mind,
I'm used to taking out.
in my mind, it's always my fault.
Are the PCs, I guess, or would be the same in
For
the manslaughter and the ag assault? So I'm
Ag
just
assault, they
printing.
came out of the same transaction.
Okay.
Occurrence, Judge.
Give me just a second.
Yes,
Hold
sure.
on. All right. So there's no bond currently set in the motion to revoke. The bonds in the two new cases have been set at $50,000 each. So I've got a motion to set a bond in the revocation, and I've got a motion from the state to increase the bond and or modify conditions in the two new offenses, correct?
Yes, Your Honor.
Okay. With regard to the, well, I guess, Mr. Coleman, you mentioned that you would be willing to stipulate to some things before we get started with witness.
I suspect Mr. Wilkerson will call these witnesses to talk about the length of residency and the ties in the community, those kind of perfunctory things. If he will shorten this proceeding, I'm willing to stipulate to those if Mr. Wilkerson.
I mean, it to some degree, that is some of it, but obviously there are more intricacies involved, including the nature of the family, the length of work, things of that nature that I think all need to be put into play here.
And I don't mind hearing the evidence. I don't want to hear the same thing. They're here, and I appreciate they're here, and I'll take notice of that. But what I don't need is to hear from all of the witnesses the same thing about work and living and all that. So if you want to call one or two that have that information,
Absolutely.
that would be great.
Yes.
I just don't want it to be the same thing, and I'll take notice that they're here and that they would all say typically the same thing, as if that's what it is.
Looks like he's on bond on 2 of those cases. I'm calling the bondsman right now.
Yes, he is.
He's already on bond. They filed a motion to increase the bond.
That's correct. So he, obviously this this very tragic accident occurred one evening. There is no allegation of any substance use on the part of Mr. Fletcher contributing to the accident that involved the death of one of the victims and the severe injuries to the other. There is some, I guess the state's theory seems to be on the manslaughter, that he was reckless in his driving on that evening, thereby causing the death of another in the course of that reckless behavior while driving, which then makes it a stretch when the state then moves on to an aggravated assault charge for the second occupant of the vehicle, because of course if there were the intent and knowing element present there of course would have been a murder charge associated with the death of the first occupant of the vehicle. We are not debating obviously the tragedy of this incident, Your Honor. Mr. Fletcher on the night in question was actually responding to a work call. That is the reason that he was out on this particular evening. It was not after curfew, it was work related. He works for Ryder, the truck company, Judge. He's a mechanic. And as the court's aware, several years ago, Mr. Fletcher had an issue with substance abuse. Unfortunately, that's an issue that affects far too many people in the community, our loved ones, or sometimes ourselves, our family members, parents, sons, brothers, sisters, children. But Mr. Fletcher has been serving his probation faithfully. He has been supporting his defendants, Your Honor. He is engaged to be married. He has custody of his biological 2 children, and then also takes care of the 2 current children of his fiance, and is now welcoming a 3rd child. They are expecting that child. Mr. Fletcher has employment to return to, Your Honor, in terms of while these matters play out in the judicial system. Obviously, there are, the state seems to highlight Mr. Fletcher's driving record as a reason to change or deny bond in conjunction with the possession charge, which he is entitled to bond on. With regard to the driving record, I would simply say if that driving record, that, by the way, I have not seen certainly a certified copy of any driving record of Mr. Fletcher, but I have no reason to doubt Mr. Coleman's representations regarding that. There are certainly rules that the court could fashion. Obviously, Mr. Fletcher has a large family here supporting him, who have also been very supportive of the Thomas family since this tragedy. The allegation has to do in terms of Mr. Fletcher's fault in that death and that aggravated assault, which seems like a mighty jump in mens rea there, Your Honor, seems to be that he was traveling at such an excessive rate of speed on the night that when the person who disregarded the traffic safety device and entered a lane, failing to yield right away. Mr. Fletcher then did not have sufficient time to react and stop the vehicle because of his rate of speed. Obviously, we haven't had an opportunity to have our own investigators take a look at any of that evidence to be able to argue it at this point in the case, Judge. I only mention it so that the court is aware of the background context under which these allegations arise, and the sole issue at present right now in the defendant's or in the defense's opinion is whether or not to provide Mr. Fletcher a bond on the charge for which he was serving a deferred adjudication sentence and for which he has not been convicted, thereby, of course, making him eligible for bond in such case. Obviously, Judge, the law has changed in a number of ways, and if this were a case where Mr. Fletcher were some violent person, prone to violent outbursts, aggravated assaults, as the state alleges one of these was, although I just don't understand how you...
I'm not gonna get into the legal, I mean, they filed what they filed, that'll be a question for later, so.
The issue here, Judge, is whether or not to grant him bail while the allegations that form the basis of the revocation of this bond come to be addressed by the court. Your Honor, as I mentioned, and I would like to put his fiance on just briefly, his mother as well. And
Let me stop everybody. Here's what I'm inclined to do. I am inclined on the two new cases, the ag assault and the manslaughter, to in part grant Mr. Coleman's motion and modify the bond conditions. I don't believe I'm going to increase them because I think I can modify them in a way that will hopefully ensure the safety of the community. What I'm going to do in cause numbers 25 DCCR 0838 and 0839 is modify the bond conditions in those cases and order as a condition of bond that Mr. Fletcher is not allowed to drive, period, ever, any vehicle while these cases are pending. It does concern me, the prior allegations with regard to driving. We've got 2010 a crash, 2012 a crash, 2012 maximum speed limit issued, 2013 speeding over 10% over, 2016 speeding greater than 15 miles over, 2018 another crash, 2021 another crash, and here we are with a crash where I'm not going to get into fault, but there is a crash and we've got someone that has passed away and someone that is seriously injured. So that if I'm going to require that, I understand there may be work issues, and that is what it is at this point. That is what I'm going to order in those two cases.
And I can understand that, Judge, but I would point out that the same issues of fault that belie this case, we're also uncertain of what...
It doesn't matter to me. We're going to stop having crashes no matter whose fault it is. When there's a common factor and there's the same thing that continues to happen, I can't help but at least have some concern that there is at least some type of fault on some of those. You know, you don't get into that many crashes without something happening. Okay, so my job is twofold: keep everybody else safe in the community and to do what's right with regard to you and your rights as well. But I've got to keep everybody safe, and based on that history at this point, while the case is pending, unless something changes later with further order of the court, you are ordered not to drive. Okay. And so I think just by the nature of obviously that order, I'm probably inclined to grant the motion to set a bond in the probation case. And so I am at this time going to set the bond in cause number 21-37809. I'm going to grant the motion to set a bond. I'm going to set the bond in that case at, that's a possession. I'm going to set the bond in that case at $30,000. The condition of the bond is the same. You're not to drive any vehicle. And it doesn't look, I think Mr. Wilkerson is correct. I'm just looking at past administrative hearings that there hasn't been an issue with any type of positive drug screen or anything like that. And
Not administratively, Judge, but he is accused of, in addition to the manslaughter and the aggravated assault, accused of violating his probation with the possession of a marijuana case and also UCW.
so what I'm going to require is the condition of that bond on your MTRP case is that you wear a drug patch if you make that bond at all times. You'll have 24 hours from the time you're released to get a drug patch put on. You have to go change it every 2 weeks, on time. It needs to be on there, can't sweat off or whatever. You need to make sure it's on and it's testable every 2 weeks. Obviously, if there is a positive drug screen for anything in your system, it's a violation of all of your bonds, and you'll be right back into custody with Mr. Coleman probably telling me I told you so. So make sure you stay clean, make sure you do get it changed when you're supposed to, and all of that kind of stuff. So that bond condition is the same on all 3 of the cases. All the bond conditions are the same on all of the cases. No driving and drug patch on all 3 cases. Anything else?
Just procedurally, Judge, ordinarily, we would defer with these types of charges, new charges, we would defer the MTRP, we'll wait on that and proceed on the new case, particularly with how serious these are. However, in this case, I just want the court to know that we would be looking to go forward on the MTRP first.
Okay.
For a number of reasons. So we're looking to amend that MTRP. We'd ask that it be set prior to a disposition in the new manslaughter or aggravated
And you would
assault.
be intended on putting on evidence of those new offenses in that hearing? I would,
For punishment, the punishment part of it is, Judge.
I mean, to prove up the MTRP.
We have other things that prove up the MTRP, particularly the possession of marijuana, also the UCW, but there very well may be some additional testimony about those circumstances surrounding
So there-
aggravated assault and manslaughter.
There obviously appears to be some additional information, or maybe just because of the size of the cases, I haven't had an opportunity to review everything.
Yeah,
But
so-
there are some allegations that I'm hearing have not been at the forefront.
So let's do this. Obviously, you need some time to get all that information. If there's going to be an amendment, if you'll please take care of that quickly, make sure anything that's alleged in that Mr. Wilkerson gets any discovery with regard to any new offenses or alleged offenses that you intend to put. That way you guys can both have all the information. Mr. Wilkerson can do what he needs to with that information, and we'll set it for an announcement. And then we'll kind of go from that announcement on where to go next with regard to either the new cases first or the motion first. All right? Sound good?
fine.
All right, thank you. Y'all are excused. And thank y'all all for being here. I don't want anybody to think, I feel like we could cut it a little short and get that taken care of. All right, you go back with the bailiff.
Thank you, Your Honor.
Yes, sir. I'm good. Good morning. All right, sir, you are Tyron Henderson? Yes. And Mr. Henderson was previously in court. We've got 3 MTRPs and a new case, and he entered pleas of guilty, or a plea of guilty in that new case, and pleas of true to counts 1 through 6 in each of those motion to revoke probation cases. I've received a pre-sentence report, updated. Wait, is there a 5th one? Or just 4?
There's 4 cases. 3 MTLPs and
That's right, something was just printed twice. Has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor.
yes, Judge.
Are there any additions or corrections?
Not from the state.
Not from the detention.
So I'm a little, well, probably a little more than a little concerned about your ability to be successful if I put you on another probation. Because you were on probation for 2 cases, an evading and an unauthorized use of a vehicle from 2021. Then you pick up a felony theft in 2023, keep you on probation, add a probation on that case. So now you've got another felony while you're on all of these probations. And you've already been to ISF. I just need some help here. And Ms. Joseph is here. Ms. Joseph, what's your thoughts?
I believe that Mr. Henderson can satisfactorily complete his probation terms, even with the addition of another term. Mr. Henderson, from the start, and I had frank conversation with him about his current situation as well as the subsequent offense. He understands the seriousness of it, the unnecessariness of this event, and he offered no excuses, which is refreshing. When I notified him of the warrant, he did not hesitate, and he turned himself in. When I spoke with him at the correctional facility, he stated that he would accept whatever the consequences were, or would be.
Well, and another thing, Mr. Henderson, which is a bit of a breath of fresh air around here, is you have absolutely no jail reports. And with the group of young people your age out there, that is pretty amazing because they're acting like fools, aren't they?
He's been in actually for 120 days too, Judge, so it's not just a short stint.
So the recommendation is ISF again, which I'm not opposed to. I'm sorry?
A state jail sanction for 180.
Okay, that's not what it says on here.
Well, that was my recommendation.
Is there an issue with misuse of drugs?
No, it's cognitive.
Safety's
I didn't recommend ISF, I recommended 180-day state jail.
just 180 days
Yes,
upfront
that's-
time.
He's already been to ISF,
I
so
know.
I don't know why we would repeat that, but that's why I recommend
Same. Okay,
state jail.
go get a feel for what it's like somewhere other than our
Yes,
jail.
yes. And we discussed that. I told him that's my recommendation, and he was willing to accept it.
All right. What do you think, Mr. Henderson? Do you have anything to say?
Judge, can I just say one thing briefly?
Mm-hmm.
He has been in for 120 days. He's had no write-ups. To his credit, every time I've met with him, he's accepted responsibility. He knows this is not a second chance, but a third and fourth chance that the court's giving him.
It's
He's
the
not
last
sinister-
chance.
Yeah.
That's what it
He's
is.
not a sinister young man. He knows that he's made some really foolish mistakes, and this last thing was him doing wheelies on a dirt bike. But I do think that he is someone that can be successful in probation. I think that he realizes too that this is not the path he wants to go down. And with every report and everything he said, he's accepting responsibility.
Yeah.
He knows he's messed up. And I do think he's somebody that, Judge, I really do think we're not gonna see him again.
So, Mr. Henderson, I want you to understand, if I go along with this today and you're back in here, I'm going to see all of this and I'm going to wonder what I was thinking today. And that's not going to be good because you will be agreeing today to a certain amount of time in prison. And so we're not going to come in here and negotiate. You mess up again, you're going to be in here getting all the sentences that you're getting. Do you understand? Do you understand?
Yes, ma'am.
Okay. So what is the agreement is just to continue those probations?
Well, we actually, the agreement was for ISF cognitive training.
Okay,
I realized he'd already been.
yeah. So we've got 2 deferreds on those 21 cases in 5 years. Okay, In cause number 25 DCCR 0520, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections, but probate that, place you on probation for 10 years. That's what your agreement is. I am going to order a $250 fine in that case. And I am going to order that you serve 180 days upfront time. And there's not going to be credit for the time you've sat, because I want you to see what it feels like to sit somewhere other than Jefferson County Jail. All right? And cause number 21-38934. Find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case. In cause number 22-39131, also find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case as well. And then finally, in cause number 23 DCCR 0899, find that you entered those pleas of true, freely, and voluntarily. Find sufficient evidence to revoke your probation, but I'm not going to do so in that case either. I am going to continue that probation. Cause number 21-38934. That's the evading arrest or detention with the use of a vehicle. So that's that first evading. I am going to, I'm continuing your probation, but I am going to extend it by 2 years. All right, so that's now a 7-year probation instead of a 5. Make sure to make that note. And then the other ones, I'm going to leave that other one. Okay. All right. So I'm going to hand you the trial court certifications in each of these cases, Mr. Smith, if you don't mind. This shows these were agreements that I followed, and so you've waived your right to appeal. This new case, I want to make sure, again, that we're very clear that if you violate any condition of probation from this point forward, you are looking at a 10-year sentence in the first evading, 2 years state jail in the first unauthorized use, 2 years state jail in the theft, and 10 years that you just agreed to in this case. Do you understand? So it's very important that you do everything. It sounds like Ms. Joseph believes in you and that you can do what you've showed that you can follow the rules in jail and for some time out of jail, but you got to follow the rules all the time or you're going to end up in prison, and nobody wants that. All right. So take advantage of this situation. When you get out of doing your upfront time, go straight to probation, follow all of those rules, and hopefully we won't see each other here again. All right. Good luck to you. And go back with the bailiff.
Are we not doing state jail upfront time, just the regular?
State jail up front. Thank you.
And I think Mr. Sorry. Philip said that the discovery exhibit for one of those is being sent by Sarah since I didn't have it.
Oh, okay. Thank you. Thank you, Mr. Smith.
Sorry.
All right. Are you LaCaven Jenkins?
Yes, ma'am.
And Ms. Perazzo, will your client waive the formal reading of the indictment in each case? Mr. Jenkins, in cause number 24, DCCR 1026, you're charged with the first-degree felony offense of aggravated robbery, and that is from March 3rd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then, in cause number 24, DCCR 1027, You're charged with a third-degree felony offense of fraudulent use or possession of identifying information from March 12th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? Answer out loud for me, thank you. And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents in each of those cases that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
And do you fully understand that? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jenkins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 24, DCCR 1026, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Let's see, is there a, I am making an affirmative finding of a deadly weapon in that case. And then in cause number 24, DCCR 1027, also find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Perazzo. All right, Mr. Falk, in cause number 24, DCCR 1891, the state's elected to proceed on count 1 only. It alleges you committed the third-degree felony offense of assault on a public servant, and that is from August 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? See, state tenders number 1.
No objection, Judge.
It's admitted. Mr. Falk, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a public servant, third-degree felony. Sentence you to, in accordance with your agreement, to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. See, Mr. Lewis, you have Kevin Tran. It says it's locked.